Good morning. This meeting of the House State Government Committee is called to order. Today's meeting is to hold a public hearing on Senate Bill 411 and the right to know law, and how that legislation impacts the law. And before we get started, if I could ask everybody to please rise, and Representative Knowles, could you lead us in a pledge?
Pledge allegiance to the flag of the United States of America and to the republic which stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Representative Knowles. Representative Knowles, could you take the roll, please?
Chair Metcalf,
Here.
Dunbar,
He's on leave.
Dush, Gobler, Hill, Irvin, Keller, Knowles here, Miller, Roy, Sagone, Sankey, Topper, Truitt, Ward, Whelan, Chair Cohen, Acosta, Brown, Bullock, Daly, Delizio,
On leave.
McCarter,
Present.
O'Brien,
On leave.
Paczynski,
On leave.
Floshberg,
On leave.
Sims.
On leave.
Thank you, Representative Knowles. Before we invite our first group of testifiers up to the microphones there, I just wanted to let the committee members know and the audience that today's hearing is going to be a little different than we normally have here in the House State Government Committee. Due to the interest in this legislation and due to the number of testifiers that wanted to be heard on the legislation, and for the 2-hour block of time that we had to work with this morning, we've tried to plug in as many testifiers as possible. We also have additional testimony, but due to the number of testifiers, this is going to be a hearing that's more for us to listen than to question. So we look forward to hearing from our testifiers. If there's extra time at the end of the testimony time for a given group or individual, then we may entertain a question or two, but I don't expect that we'll have a whole lot of time for questions this morning from the committee, but we're here more this morning to listen to what the concerns are and what the input is from our testifiers. So with that said, I'd like to invite Ms. Emily Leader, Mr. Tim Wachter, both with the PSBA, along with Elam Herr, with the Pennsylvania State Association of Township Supervisors, and Ed Troxel with the Pennsylvania State Association of Boroughs. And you all, and Representative Dush just joined us. So you all can begin when you're ready. And let ladies go first, I guess would probably be appropriate.
Isn't that nice? You also put me first. I appreciate that. Good morning, Chairman Metcalf and members of the House State Government Committee and others. My name's Emily Leader, and I'm Senior Deputy General Counsel at the Pennsylvania School Boards Association. Some of you may know that I've worked in some capacity on the current right to know law since you were writing and amending the bill. And I've spent many years training our members and presenting on the law in connection with this. Today I have with me a member of our Solicitors Association, Timothy Wachter from Knox, McLaughlin, Gornell and Senate in Erie. As Tim will tell you, his firm represents over 60 school districts and municipalities. We're very pleased that he could come with us today. We have submitted extensive written testimony. I'm not going to spend a whole lot of time on that. It's there for you to know where PSBA supports this bill, and there are a number of things we really like in it, and where we have some concerns about whether the language carries out the intended purpose. And then we have a few, as you'd put it, asks, which we've also put in there.
I would encourage you to make sure you highlight those to us now, though, because it may not get read while we're having the hearing.
Okay. I will. Our Supreme Court has said that the right to know significant law significantly expanded public access to governmental records with the goal of promoting government transparency. There's a survey that's attached to our written testimony that gives you some information and has a couple charts that show you the problems that open records officers for school districts have experienced with the law, and also which kinds of requests take the most time to respond to. You will find in this survey that the 233 out of 585, I think it was, open records officers responded to this survey, so just very large statistical number. And what they will tell you is that over 80% of their requests are easy. They get a request, they process it, so it's done in less than an hour. But there are a group of requests that are more burdensome to them, and our requests for fixes address some of those. For one thing, all of our members are dealing really consistently with requests from out-of-state commercial requesters, and they're not just getting them once in a while, they're getting them from the same vendors a few times a year. While there's a change in this law that talks about charging for the time it takes to respond to commercial requests, it's been written in such a way that the first hour of time expended would be free. We don't see any rationale for why Pennsylvania taxpayers' resources should be diverted to commercial requests, money-making requests. We don't see how that promotes government transparency. In particular, when this law was passed, we had to define requester as being any citizen of the United States because of a Third Circuit decision. We don't have to do that anymore. The United States Supreme Court has since issued a decision that makes it clear that states can define requesters in their open records laws just as citizens of their state. That doesn't completely solve the commercial requester issue. Some are from in-state, others will just move to an in-state requester, but it would be of assistance. The other concern that we have with the 19% of requests that take a minimum of an hour is some of those can take weeks, some of those can take the salary of a fairly high-level employee for 40 hours, 50 hours, and with our ever-shrinking staffs in school districts, we've gotten very lean and mean, and we don't have the resources to divert our employees' time to that degree. So the question would be whether or not it would be possible with regard to non-commercial requesters to have them pay some amount of the cost of doing business, of processing these requests after the first hour. That would be more akin to what's currently in the bill for commercial requesters. Again, it's a comparatively small percentage of requesters, and actually our main goal here is not to avoid answering requests, but to have people focus their requests more, to have them target what they really want to know about government, and do the most expeditious requests they can. And you'll find from Tim that he's had some experiences on that. I'm going to turn it over to Tim because I'm concerned about time.
Thank you very much. As Ms. Leader had indicated, I'm an attorney at Knox McLaughlin Gornall Senate in Erie, Pennsylvania. We have the largest government services provider. We are the largest government service provider in northwestern Pennsylvania, representing over 60 government entities. We have a dedicated staff to service solicitors in those roles, and I have provided the right to know services for all of those clients since the inception of the law. I don't want to be duplicative and speak about the commercial requests, except to state that what I have found is that the commercial requesters are asking for data, vendor data, taxpayer information, for the purpose of fueling the for-profit needs of those companies. They are selling access to the data, they're selling data itself. So essentially the Pennsylvania taxpayers are filling the inventory of these companies at the expense of the taxpayers. And quite frankly, that does nothing to advance the purposes of the right to know law, and it's a waste of money. There are other states in the country that prohibit commercial requests or allow for the charging, and that is not to frustrate the purpose of the right to know law, but that is to at least make it a revenue neutral exercise for our local taxpayers. The second item that I'd like to address is that of Section 707D in the trade secret and confidential proprietary information section of the right to know law. That section does two things which are quite frankly unrealistic and confusing. The first of which is, in order for data to be protected as being a trade secret or confidential proprietary information, the provider of the data must submit a signed written statement claiming that the data is confidential proprietary information. Secondly, there is a different set of timelines that are included in the law for which the agency has to comply when you have such instances, and those timelines provide for a period of time that is less than if you had your traditional extension period that is in place. So you have a more complex request in a less period of time to do it. Back to the signed written statement. Oftentimes I have school districts that go out for technology RFPs. They get submissions from multinational companies, Dell, Google, insert big name here, IBM. And it is an industry known fact that much of the information that is submitted is confidential or trade secret information. Yet no one has ever submitted a signed written statement claiming as such. So I am faced with the unenviable task of speaking to my clients and advising them to err on the side of caution and expand their redaction abilities underneath the law to avoid a lawsuit for the breach of the security promises that have, or requirements that are provided by the Dells and the Googles of the world, rather than get sued by them or over-redact. That needs to be taken a look at, and we have some sense that is placed into the law. And I ask that the requirement for the signed written statement be removed and that the time periods be augmented such as the written testimony has provided for. Additionally, the bill allows for an increase in the individual who is to receive the request. Under the law now, it states that a request is to be addressed specifically to the open records officer. Under the proposal in Senate Bill 11, it speaks to an allowance for the administrative officer to also be an approved receiver of the request. For years now, we have litigated the issue as to whom is the correct individual to receive a request. And now our courts have finally come down and said it must be addressed to the agency open records officer. People get it now. By augmenting that and allowing for an administrative officer to also receive the request, I foresee much more litigation on the basis of who is the administrative officer. To my knowledge, that is a new term that is being inserted into local agency law, into the world, and typically, I don't know who that is. Does that mean it's the governor? Is it his chief of staff? Do we expect the governor to forward all requests specifically to the open records officer or to facilitate those requests himself? The law itself speaks to the fact that the open records officer is the only person who has the ability to facilitate the requests. But yet we're going to add an additional person in an undefined term as to whom that person is, for who is going to receive the request. So I ask that that be removed. Additionally, with respect to pre-decisional deliberations, this is one that I've been doing right to know law since before it was effective. I've been giving seminars on this. We've spoken to our clients for years now. I still don't understand the pre-decisional deliberation exception. We ask that you tighten it up, provide for some real clear rationale as to how that is to be implemented. Additionally, we'd like to speak to the litigation. What I often see is the right to know law used as pre-discovery. Whether it's an individual who's looking to sue the government entity, or whether it is employees of the entity that are wrapped up in family law issues, such as divorce issues, where we see right to know requests for payroll information, right to know requests for work periods, for duties, whether they're on vacation. Pennsylvania taxpayers are being forced to pay for the provision of this information for interests that have nothing to do with the operations of government. And we ask that that be clarified such that either the agency be a party to the litigation, if we're going to have that, or to ensure that, actually to prohibit the litigation requests so that we can have an assurance that such requests would be followed through with the discovery processes that are currently in place. Lastly, one comment I'll have that is off the PSBA record is that of the bill allowing for the PIAA to be a local agency under the law. I believe that will create a large amount of confusion as appeals from the Office of Open Records for a local agency go to the county court where the agency is located. If someone from the Erie School District was to make a request of the PIAA and there was to be an appeal, we would be forced to go to Cumberland County in order to appeal from the Office of Open Records in order to have that heard. That's unreasonable, and we request at least it continue to be a state-affiliated agency where any appeals would go to the Commonwealth Court, and we'd only have to travel to Pittsburgh as opposed to Cumberland County. With that said, and in light of our time limitations, I will yield to Mr. Elam Herr.
Thank you, Mr. Chairman. My name is Elam Herr. I'm the Assistant Executive Director for the State Association of Township Supervisors, and due to the time constraints, I will not read the testimony. You will all have a copy. I just ask that you take the time and review it at your leisure. That information in there will supplement both what I have to say and give you additional information. I also want to say real quickly that our association continues to be a strong advocate of open government and the rights of our citizens to these public documents. Just this past fall, we put on 9 sessions on open records for our membership. I also want to say that I personally worked diligently on Act 3 in 2008, and then as now, I still feel it's a balanced document, but numerous things have transpired over the years, and that's the need for Senate Bill 411. 411, it does address numerous concerns, and I will repeat a little bit of what the previous 2 speakers said, and I will discuss only 2 of the issues. So again, I ask you to read the testimony. And the 2 issues that we hear from our members the most are, 1, the inability to recover costs incurred when a commercial entity requests information that is going to be used for commercial gains. And the second one is privacy concerns. Under the commercial request, the existing law states that an agency is authorized and needs to provide information when a request comes in. Our concern, or our members' concern, is that the information coming from these commercial requests is being used for financial gain of an individual or an entity at the expense of the taxpayers. Originally, when we looked at this law a number of years ago, that was not the intent of the Open Records Act. The Open Records Act was to provide the resident citizens, and at the time, anyone in the United States, the ability to get information vital to them as far as the actual working relationship of that agency. 411 in Section 1307 would add a new section to correct this. It would allow for the municipality to recoup some of the cost for compiling, retrieving, reviewing the records that are being requested. It also would require that the applicant would have to state on a form prepared by the Office of Open Records that it is or isn't going to be used for commercial purposes. It does not ask what it's going to be used for. That's none of the municipality or agency's business. It just says, is it going to be used for commercial purposes? There are penalty provisions if somebody would mark the wrong box, which then would hopefully prevent future activity of such sort. It also states that the fees that we could collect would be limited to the lowest paid individual or employee that could compile that information. So there is a limit on it, that somebody can't say that we're using it for purposes of getting money. And it also says that the first hour is basically free. Now, I just heard the previous speaker state that they have some concerns with that. We feel if we can give an hour because of the complaints that we have, most of the time it goes way beyond an hour. Also, there is an exclusion for charging any fees for newspapers, universities, and scholarly, research. The second issue that we have is the privacy concerns that are presently in the law. There are 2 portions to this. One is the releasing of financial numbers of a local government itself and the confidential personal information. Now, again, information as far as the financial aspects of the local government, what the local government brings in, what the local government puts out is public information. But under the existing law, the information such as the financial institution's account numbers. So you could go in, literally, ask what financial institution you are and what your account number is. You can ask for the routing numbers, the credit card numbers, passwords. Presently, they all can be requested. Now, I can tell you, I think that if anybody comes in, myself, if I go into my township and ask for that, my township will deny them. Because why do I need that information? Unless I want to borrow some money from the municipality. But besides that, I think my township would probably deny it. I think when it would be appealed to the Office of Open Records, they would deny it. But the end result is we still have to defend it if it goes any further. Why is that information? As I said, the information, the financial information should be public, but that type of information goes a little bit beyond what the public needs to know. The second part of that issue is the financial information of the public employees of the agency. Under existing law, there are certain things that have to be public. Again, what the agency pays an employee, the gross amount, should be public. That is an expenditure of the municipality or any agency, should be. What is deducted from that gross amount is really a private concern. Nobody needs to know what I have taken off my paycheck. Once the paycheck is given to me, it is my money, no longer the municipality or the agency's money, and this should be clarified. Now, certain things are already excluded. When you get a paycheck on your W-2s, you know, Social Security, certain things that are coming off. But other things that are listed as deductions, you could have payroll deductions. Why does anybody need to know how much I'm taking out and putting into a payroll account? So the response is that things in this bill clarify, clarify and clean up some of the issues that we didn't think about years ago. But with today's society, things are out there, bigger changes. One last thing before I turn it over to Ed is recently, our township's got a request. Well, back up a second. Recently, the Office of Open Records was notified by an individual in prison that he did not receive the information from the municipalities, the political subdivisions that he sent out requests for. Under the law, Office of Open Records has to start an investigation. They contacted our townships. Our townships said, we never got the request. After several of these came into the Office of Open Records, they found out that the gentleman serving in one of the federal hospitality establishments in the state was putting out a request to all municipalities, all political subdivisions, asking for information. He never sent it to the municipalities. He just skipped that step and went to the Office of Open Records and asked for it. But again, our people had to do research to find out they never got the request. What 411 is trying to do is clarify some of these things. There's a lot more information in our written testimony. I just ask that you please read it. Ed.
Thank you, Elam, and thank you, Chairman, members of the committee. I'm Ed Troxel with the Boroughs Association. Basically, you've heard about the commercial request. You've heard about the out-of-state educational request, those areas like that. Let me give it to you from a tact of the local government, a borough government, what they have to deal with. Ever since we flipped the presumption, which is a good thing, okay, putting that presumption now has become liable to the borough. And the borough has to establish an administrative mechanism to deal with that information. They have to capture what information. They also have to categorize it and catalog it. So you've actually layered another role for local governments to play, which will have to be paid for in some way or another. What I've provided here also in my testimony for you, in the sake of time, is a case study. And you'll notice what we've done is actually looked at one of our boroughs in the middle of the state,
This is a typical borough of maybe 1,000 people, 3 full-time people, 9 part-timers, et cetera. And getting these type of requests that you're talking about is, for permit, and, for building permits, areas like that. It's just been, you can actually see from the tone of the case study itself on the second page there, I have it italicized. You'll notice the frustration that's in the voice of the secretary who wrote this to me. So basically, what I'm looking to do and what we're looking to do is basically, let's look at these commercial requests. Let's look at these out-of-state educational requests. We feel they can really burden us when it comes to providing practical information for people. Our association truly supports the bill with we feel that moving forward on these commercial requests is going to be very supportive and very helpful for us. Last of all, I just want to thank the committee for allowing me to present in the sake of time. And if you have any questions, contact me offline, anything now. We're happy to try and answer your questions. Thank you.
Thank you. Thank you all for your testimony this morning. Appreciate it. It will be beneficial to the committee. Thank you. Next testifier is Ms. Melissa Sandusky, Media Law Counsel with the Pennsylvania News Media Association. Good morning.
Good morning. And thank you for the opportunity to appear and offer testimony before the House State Government Committee on Senate Bill 411, which would amend Pennsylvania's right to know law. My name is Melissa Sandusky, and I'm Media Law Counsel for the Pennsylvania News Media Association, which is the statewide trade association for newspapers and online publications, and we count more than 300 print, digital, and related media organizations as members. As Media Law Counsel at PNA, my primary job responsibility is to answer questions from journalists, and as a result, I have the opportunity to talk to them on a daily basis about their problems with access in the state. The PNA, founded in 1925, has for decades advocated for legislation that improves public access laws in Pennsylvania, and we were heavily involved in the legislative efforts that led to Act 3 of 2008, Pennsylvania's new and current right-to-know law. And we appreciate the opportunity to share our thoughts on Senate Bill 411. With this background in mind, we believe Senate Bill 411 makes some improvements to the law, but we also believe that there are some significant issues with the proposal and many issues that negatively impact public access that are not addressed by the bill at all. First, I'll touch on a number of the positive aspects of the bill that we support. First, the bill would increase public access to state-related institution records, and their police departments would be expressly defined as local agencies under the law. We have advocated for greater applicability of the right-to-know law to Penn State and other state-related universities, and we support this increase in public access to their records under the law. PNA also supports the expanded definition of local agency in Senate Bill 411. The bill would now expressly cover economic development authorities and industrial development authorities. The bill would also, for the first time, define time response log, which is a public record under the law, although we do have concerns that this definition could be undercut by the proposed changes further along in the bill in Section 708B-18. The bill would include in the definition of time response log the location of the emergency response. This change recognizes the critical importance of geographic information in a time response log. Without access to geographic information like cross street, mile marker, or address, there is really no way to gauge the timeliness or appropriateness of a response. Senate Bill 411 would also provide access to the final safety inspection report made pursuant to law or regulation, and we support this change. Senate Bill 411 would clarify that information is to be provided in any format in which it exists. The bill would also expand the time to file an appeal of a denial by 5 business days. These changes are all positive, and we support them. Unfortunately, the bill contains several provisions that limit access, and we believe they should be modified or eliminated in their entirety. First, problems with the bill, home addresses. As amended, Senate Bill 411 would create a blanket exemption for the home addresses of public employees. Home addresses are a critical tool for identifying individuals, and address information is and will continue to be expressly public by law and widely available. The media and the public use home addresses in a number of ways that advance the public interest, including verifying residency requirements for those seeking public office and certain public employees. Members of the media also use address information on a daily basis to confirm the identity of individuals about who they are writing. This includes individuals charged with a crime, as well as those being honored in their community. For obvious reasons, it's critical that these individuals are properly identified and that others are not incorrectly identified. As a more practical matter, home address information is widely available through private databases, internet search tools, voter registration, court, property tax, and other records made expressly public by law. In the years since the white pages were the primary source for home addresses and phone numbers, home address information has become more, not less, publicly available. Voter registration records used by every public office seeker in this Commonwealth contain home addresses and dates of birth, and they are expressly public. Court records and property tax records likewise contain address information as well. Senate Bill 928, which passed the Senate 46-3 this session, would require PennDOT to sell basic driver information, including name, address, driver's license number, and date of birth, to distributors and insurers. I believe that bill is currently pending in the House Insurance Committee. Any suggestion that a blanket exemption for public employee addresses in the right-to-know law is necessary for public safety reasons is disingenuous at best, and we believe this provision should be removed in its entirety. Access to parties in litigation. Senate Bill 411 would deny public records to parties that are in litigation when the records relate to that litigation. In other words, the bill would permit a party in litigation to request records would prohibit a party in litigation to request records that any other citizen could request and be entitled to receive under the law. This provision is unworkable and easily avoided via third-party requests who are not involved in the litigation. My neighbor, my mom. It's easy to work around this provision. When a record is public, it's public, and as such, it must be provided under the law regardless of who is making the request. Time response logs. Again, and as we noted above, the definition of time response log would expressly include block information, cross street, or mile marker, but the exemption itself in Section 708B18 exempts the home address of the person who called. This must be clarified. Either the language in this section, 708B18, should be stricken, or it should be modified to add after emergency dispatch, except for information in time response logs. Other issues include the bill would also expressly exclude local tax collectors from the definition of local agency. It would restrict access to payment information for utility bills and would create a blanket exemption for volunteer records of records of volunteer fire, ambulance, and similar first responder organizations. I have provided more information on these issues in my written testimony. I would urge you to read through that as well. There are other issues outside of the bill's language that the bill doesn't address several issues that we'd like to see addressed, including the criminal and non-criminal investigations, which remain overbroad and over-applied. They last forever. They provide less access than the more restrictive 1957 version of the right-to-know law, which made agency decisions and final reports public records. The deliberative process exemption is likewise overbroad and overused, and we welcome any opportunity to restrict these exemptions in this or any other bill. We support some things in the bill. We don't like other things about the bill. We welcome the opportunity to work with this committee as we move forward to improving public access, and I thank you for your time, and if you have any questions, I'm happy to answer them.
Thank you for your testimony. Appreciate it. Our next testifier will be Mr. Andy Hoover, Legislative Director for the ACLU. Good morning.
Morning, Chairman Metcalf, members of the committee. Thank you for the opportunity to be here today. Like the previous testifiers, I will summarize my written testimony. I am here today on behalf of the 23,000 members of the ACLU of Pennsylvania. The American Civil Liberties Union was founded in 1920 as one of the nation's oldest and leading civil rights organizations. Like other public interest organizations, the ACLU of Pennsylvania regularly utilizes the law in our work, and it can provide crucial information about the compelling civil liberties issues of the day. For example, the law allowed my colleagues to uncover new information about the practice of civil asset forfeiture in Philadelphia, Montgomery County, and Cumberland County. While one district attorney claimed his office engaged in, quote, lengthy cooperation in our research, it was, in fact, the teeth of the right-to-know law that compelled him to cooperate. A strong open records law forces agencies to operate in the light of day. So in my testimony today, I will provide some ACLU perspective on some of the provisions of SB411 and also on some areas of the law that we believe need to be addressed. First, the ACLU supports the provision that establishes the Office of Open Records as an independent agency, and we also support the provision that extends the appeals period to 20 days. On the latter, everyday citizens aren't spending their work time dealing with open records requests. They're often doing this on their off time to find out what's happening with their local and state governments, and the extension of 5 more days gives them more time to do that. I do want to address the issue of prohibiting inmates to use the law with some exceptions. SB411 explicitly prohibits inmates from requesting records and then enumerates 11 exceptions to that rule. The exceptions all relate to the inmate's personal situation, and it's important to acknowledge, and I acknowledge this every time the press calls about this issue. They don't usually use this quote, but then Senator Pileggi, when he first crafted this legislation 3 years ago, he and his staff, particularly Eric Arneson, who's now the director of the OOR, were open to suggestions on what exceptions should be included for inmates. And the ACLU of Pennsylvania is grateful we had the opportunity to advise the senator on that provision. And the current language of the bill reflects those discussions. We do have some remaining concerns, though. First, the first concern is purely practical. What reasonable exceptions for inmates have not been considered? It is impossible to know now what issues may arise in the future in which inmates legitimately ask for records not covered under these exceptions. An attempt at a partial prohibition on inmates' use of the law creates a situation in which records that should be open and available to them will not be because none of us have thought of a particular hypothetical at the time of drafting the legislation. The second concern, frankly, is philosophical. What kind of open records law does the Commonwealth want? Do we want a right to know law, or do we want a right for some to know law? Cutting inmate access to the law sets a disturbing precedent in which a population can be blocked from using the law simply because one agency finds that population's requests to be challenging. There are probably municipal officials who would like nothing more than to exempt certain citizens from the right to know law. Inmates also have a unique relationship with the Commonwealth that those of us sitting here today do not have. By definition, they are in the custody of the Commonwealth. Thus, they have a vested personal interest in how the Commonwealth functions. Most reasonable people agree that government functions best when it is open and accountable to the people. That is the essence of our democratic system. But the Department of Corrections and the county jails are less open than other areas of government as they control all of the evidence about their operations. To be fair to the DOC, individual secretaries can make executive decisions about how open to be about the department's operations, but very little compels them to do so, unless the department is investigated by another agency or is sued. Inmates play an important role in bringing to light the operations of the DOC and the county jails, and the right to know law is one way in which we learn more about how the department operates. The inmate prohibition in SB 411 could lead to less accountability in our prisons and jails. The ACLU also has concerns about the prohibition on parties to litigation and prohibiting them from obtaining open records. And you heard the previous testifier mention that we agree with the Pennsylvania News Media Association on this issue. I do also want to address an issue that's going to be coming before you more than likely. It's certainly before the courts right now, and that is access to footage from police cameras. Senate Bill 411 does not speak to the issue of availability of police camera footage, but based on current activity in both the General Assembly and the state courts, it is clear there is movement to resolve this issue. In Pennsylvania State Police v. Grove, the Commonwealth Court ruled that footage from a police dashboard camera is presumed open unless it falls under the investigation exemption of the law. Although the case does not involve footage from a police body camera, it is reasonable to believe that this type of footage would also fall within that presumption. The movement of SB 411 provides the General Assembly with an opportunity to address this issue, and the ACLU of Pennsylvania has crafted best practices that balance both privacy and the public's interest in transparency and accountability in policing. Police video footage that is of public interest must be presumed to be an open record under the right to know law. Incidents of public interest include any arrest, a shooting of a person, or other uses of force by a police officer, and a dispute between an officer and a person about the facts of an encounter. In order to deter the use of cameras for widespread surveillance, public humiliation, or gossip, police video footage that is not in the public interest should be exempt. The purpose of utilizing police cameras is to allow the public to better monitor police behavior and to clarify disputed facts in a situation. Although they are not effective 100% of the time, these cameras can provide a tool for both monitoring inappropriate behavior by police and for clearing police officers who are falsely accused of wrongdoing. The purpose of police cameras is not to provide embarrassing and entertaining fodder for social media and reality cop shows or to re-victimize those who have been subjected to violence or crime. That's why finding a balance between public accountability and privacy is critical. And finally, I want to address the issue of burden and appeals. The right to know law needs revised to provide less of a burden on the requester in the appeals process. Records should be presumed open, and the burden should always be on the agency to prove why a record is exempt. Now, although the law places the burden on the agency to show that the record sought is exempt from the law, when a request is denied and the requester appeals, the law has been interpreted by the Commonwealth Court to place the burden on the requester to then prove that the records do not fall into the exemptions cited by the agency. This is a problem because agencies will frequently cite boilerplate exemptions without giving any individualized reasons why the record is exempt, or even say whether or not the record exists. This makes it virtually impossible for a requester to prove that a record is public on appeal. When agencies do not meet their burdens under the law to say whether a record exists and provide specific reasons why the record is exempt, the burden should remain on the agency to prove that the record is exempt at the appeal stage. Otherwise, agencies have no incentive to provide this information prior to an appeal, thus defeating a central purpose of the 2009 revisions, which was the shift to burden to shift the burden to agencies to prove records are exempt, rather than requiring the requester to prove records are public. And again, I did not note this when I started talking about this particular section, but that is not currently addressed in Senate Bill 411, but we believe it would be a good use of the committee's time to examine that issue. So again, the ACLU of Pennsylvania believes the regular revisiting of the right to know law by the legislature is an important exercise to ensure that the law is operating with as much transparency as possible. Chairman Metcalf, thank you for the opportunity to be here today.
Thank you for your testimony. Our next testifier will be Mr. Brett Woodburn with the Pennsylvania Bar Association. Good morning.
Good morning. Good morning, Chairman Metcalf, members of the committee. My name is Brett Woodburn, and I'm here in my capacity as chair of the Real Property, Probate, and Trust Law section of the Pennsylvania Bar Association. I'm here on behalf of the approximately 1,900 attorneys who are members of our section, many of whom will be impacted by these proposed amendments. On behalf of the Real Property, Probate, and Trust Law section, we do support with modification the proposed amendments to this act. We need to make sure that the amendments to the Right to Know law clarify that recorder of deeds records, delinquent and current tax real estate records, real estate tax assessment records, and county and municipal geographic information system records remain public records with easy access to the public. It's also important that we ensure that under these amendments, the ability to search records by name and/or address remains available. Now, no advance notice is required to property owners because imposing such a requirement will affect the ability for attorneys to search records, title abstractors to search records, individuals within our Commonwealth to buy and to sell property. It's critical that we have practical access to these property records, including owners' names and addresses. In 2015, the Commonwealth Court held under the Right to Know law, public school employees are entitled to notice before their names and home addresses are disclosed. If this right to notice would be applied to assessment records, to county and municipal GIS information, to building records and records maintained by the taxing authorities and recorders of deeds, the ability to efficiently access public real estate records would be placed in jeopardy. Searching these records by name and/or address is an essential function for, among other things, performing title searches, for economic redevelopment and development processes, and to obtain real estate tax records, payment certifications, and to facilitate code enforcement efforts to address blight or to address other municipal purposes. The list of cases and authorities establishing the public nature of these records is legion. While limitations on formatting and other aspects of providing this information to individuals and entities that request this record in bulk is absolutely appropriate, we must not limit the right to practical access of these records. Part of ensuring practical access to the property records includes ensuring that the costs associated with accessing those records remains reasonable. Without placing parameters on what constitutes reasonable, these fees to access can become abusive, operating as either a tax or as a bar to access these, financial bar to access these records. The Municipal Planning's Code does permit imposing fees or enacting fees, but the fees must be related to the actual costs of the services provided. Municipalities are not permitted to use this authority to implement fees at a rate designed to generate revenue or to frustrate or impede other lawful acts such as filing for zoning applications. Amendments to the Right to Know law should define reasonable costs to be limited to recovering the costs associated with accessing and retrieving the records. Moreover, many individuals will need to access these records only on a sporadic basis. Therefore, requiring a subscription fee should be an optional or remain optional at the discretion of the user and not mandated by any agency or office. Our section is not opposed to charging higher fees for individuals and organizations that seek to use such information for general solicitation or for reselling of this information in bulk. However, the definition in the proposed amendment of what constitutes commercial purposes is currently too broad and encompasses individuals and professions that are not reselling the information in bulk or are not using this information to generate solicitation lists. Attorneys, title abstractors, real estate licensees, for example, all access these records on a regular basis for their clients. In addition, these professions and individuals are doing so as part of their business. They're doing this to pursue the ultimate goal of making a profit, certainly. However, it is not the collection and generation of the information that is for profit. The profit is derivative of that. The manner in which attorneys, title abstractors, real estate licensees, and others who access the records as per part of their professions and jobs to use this information is truly divergent from those who intend to generate profit directly from the information, either as selling it to data mines or using it to generate solicitation lists. Title abstractors are accessing and collecting this data at the behest of attorneys or title agents, lenders, real estate agents, or others, and it is in response to a specific request. The data provided by these records is not being used en masse. It is not being resold as a means for generating revenue. It's the result of imposing additional fees on attorneys, on title abstractors, on real estate agents, on the general public will effectively act as a bar to the public. It will impede the ability of the average person to buy and sell real estate. The section on behalf of the PBA will support the provisions of Senate Bill 411, under which pricing for attorneys, title abstractors, real estate agents, and others who are not reselling the information in bulk, who are not using the information to generate solicitation lists, is kept at a minimum, is kept at a cost to recoup the actual costs incurred. The section is comprised of attorneys from a wide array of practices. Not only do we include attorneys that are defined as the typical real estate attorney or the typical estate attorney, we also include attorneys whose practices focuses primarily on commercial matters. We have a large number of family lawyers. Our members include attorneys who represent associations and corporations, and we have a lot of members who are from solo and small firms, or in other words, known as the general practitioner. Our section was unanimous in its concerns over some of the proposed amendments and the scope with which the amendments are drafted. However, it's also unanimous in the overall support of the bill. The changes and clarifications contained in our testimony, from our perspective, are intended to better hone what the purpose behind the Right to Know law is, what the purpose is behind the proposed amendments. Our testimony, our suggestions, and our ability to work with the language, with the various individuals working on the language, will continue to give the effect to the principles behind the law, and will also balance, though, the rights of the individuals within the Commonwealth, not just professionals, but also the citizens of the Commonwealth, to enact or access that information. Accordingly, the Real Property, Probate, and Trust Law section of the Bar Association does support the bill and the amendments to the bill, but with certain modifications. And with that, I conclude my testimony and offer any questions you may have.
Thank you, sir, for your testimony. Appreciate it. Our next testifiers will be Mr. Richard Varn, the Executive Director for the Coalition for Sensible Public Records Access on behalf of Chrissy Associates, and Also, Kia D. Floyd, the Director of State Government Affairs with Relax Incorporated on behalf of Chrissy.
Hi.
Welcome.
Good morning. Thank you, Chairman Metcalf and all the members. Thought since I'm new to this area, thought I'd introduce myself and the group that I represent to start. My name is Richard Varn. I am a resident of Pennsylvania. I live in Newtown. I'm originally from Iowa. I served in the Iowa legislature for 12 years in the House and the Senate, chaired the Education Committee, Human Services, Judiciary, was Majority Whip, and also chaired a Communications and Information Policy Committee for both the state and for NCSL. And I have been a CIO in the administrative branch for the federal, state, city governments, and universities. So I've worked at information management and managing the laws of our Public Records Acts in a number of states and at the state level. So I've been working with the Coalition for Sensible Public Records Access now for about 10 years. And their advocacy is around trying to balance the access to government records between the various interests that compete. So the real message from CSPRA is balance. And it's in the name, sensible access. So I want to highlight that we have a letter that we've submitted on the bill. I'm going to use that as a guide. We have two papers I'm going to refer to. One of them is the benefits of commercial access to public records, and the second one is how to manage burdensome requests, and I'll refer to those in my testimony. I'm going to leave a few minutes for Kia to talk about what they actually do with the records when I'm done. I'll try to keep to your 10 minutes. I'll talk fast then. So the first issue is the commercial request. And we think that the issue really here is burdensomeness. It isn't the fact that they're commercial. If it is in fact the policy or the issue that someone eventually makes money off of something that comes from the government, we kind of find that position a bit absurd. When we think about the person who starts a pizza delivery business, we don't charge them extra money because they make money using the roads of Pennsylvania. We don't charge them extra for that. The law folks, the Bar Association, I'm also a lawyer, Bar Association says, we don't care if you tax commercial entities, just don't charge us. You know, don't tax me, don't tax thee, tax the person behind the tree. Well, lawyers make money off public records too. We don't want to charge them extra just because they make money from it. A person gets an educational degree. Do we want to charge them extra because they use public resources to get their education? And if they go make money with that we should charge them extra somehow for something they gained from government? We don't think that the reasons that people do things in life should be driven by whether or not they desire to make money. In fact, we think making money is good. That ends up allowing us to collect taxes and to have businesses that actually function. Many of the commercial entities that we're talking about here aren't the gadfly, the problem. They aren't creating burdensome requests. They're often automated, technologically driven requests that are easy to fulfill through a simple interface, an advanced programming interface, or a way of just having a data access. They're often bulk requests. They're low cost. They're easy to deliver. As a chief information officer, what I've watched over the last 30 years is the cost of data, the cost of access has come plummeting down to the point where it's hard to even meter anymore and justify charging for it. And yet we're still talking today as if we're having a very expensive process to deliver this data. Most of the commercial requests are not in fact that, and the uses that are made of this data are manifold. I want to just highlight a few of them, and this comes from this paper here. There are many life events that have to happen, buying property, when people are making any kind of credit transaction, when they're applying for any kind of risk-based activity. This data becomes critical, and commercial entities often provide that data. Person and business locator services, collecting child support, collecting bad debts, finding witnesses, finding evidence for crimes. Background screening, personal workplace safety. The data that is in public records is used and compiled by these entities, and many institutions in Pennsylvania use that in order to provide a risk-based decision about hiring and other activities. Public safety. Many of the records that commercial entities collect are in fact used by public safety entities to do investigations. So government is one of the main users of these commercial services. So that whether you're a child support agency or an investigative agency of various types, you will use these commercial services, as will the press. So you say you want to exempt the press in the current bill. Well, the press might use LexisNexis to do research a story. Well, LexisNexis is a commercial entity that draws from public records and compiles it with other data, provides value-added services that the government cannot and really should not be providing to the public. And then the press uses those services in order to be able to investigate efficiently and effectively a news story. And we like that. We want that to work. A nonprofit organization or an academic institution also might be exempted by the bill. They also use commercial services to do their work. So the line is not clear. between what is a press entity anymore, what is a nonprofit activity, and what is a commercial thing. And all of them are using each other for their own benefit and to our benefit. And you help residents to exercise their right to know by having these commercial services available. Oftentimes, it is difficult to use a public service that's not designed for these kind of consumer interactions to do something that an individual wants to do. Commercial services then provide those services to the individuals in Pennsylvania, and they use those to enhance their right to know about what's happening in Pennsylvania. That covers that paper, and I encourage you to read the details of it. How to deal with the burdensomeness, we think, is not the problem of the commercial entities being characterized as the problem alone. You have many things. An individual who is exempted in the bill can make a burdensome request, and it causes the same problems that local government is experiencing and is telling you about here today. We highlight that if you can foresee that these requests are going to come in on a regular basis, that you should set up your system to be able to respond to them. And as a former chief information officer for a city, we tried to establish ways that people could easily access this information so it did not burden us. So the more you can design the solution to identify what kind of records requests you're going to get and design simple interfaces to that data for the people that want to draw that data out, the less burden there is on government and the more opportunity you have to actually serve those people in other ways. Secondly, you want to require substantial manual processing. If there is a manual process, you can't get around it with a technological fix. If there is a manual problem you have to address, then look at how to maybe automate that manual process, or at some point consider if there is an excessive number of hours that's being used, then you can start to draw the line there. If you do have no way of getting around the problem, it is a manual process, it is incredibly burdensome to local government, then consider that solution. Just for the sake of time, I'll just highlight that we do go through this framework for how to manage burdensome requests. We've supplied it to many other states, and it has been used to try to help people work through and solve the problem of burdensome requests without just creating a category of people that you want to limit or charge more to. So the last issue I want to address, and how are we doing on time? A couple minutes left. Last issue I want to address, and I'll turn it over to Kia, is the issue of the local address of public employees. It's been highlighted in other letters that you've received that I've read, and it's been highlighted here today, that's many hundreds of thousands of Pennsylvanians that would no longer have their data available in the public record. And just to highlight a couple problems with that, it's been mentioned. Land records can't be secret. You can't have secret ownership of land. So we know that's one place that you will have to, if you ever want to sell your home, if you want to transact business, get a home equity line of credit or anything else related to your home, that you will have to have your information known. That's the way our property system works. We all know that. So we can't have these incongruous facts just sitting in front of us. We know that public address of a person is not a private fact. The problem that we've been having is that these bits of information have been used to allow access. And I'll give you an analogy. Because I know your your address of your house, that should not give me the right to the equivalent of a key to open your door, walk in, look around, and take anything I want to from your house. Yet that's been the problem. We've used bits of information to secure access to accounts. That's why people have gotten oversensitive to this, and we have not yet solved that completely. But through devices like this, we're beginning to make inroads in that. I have a fingerprint reader on this phone. That gives me a biometric. It's a device that I have to carry around that gives me access. And when I check out at the lunch counter at where I work, I push my finger on this, and it sends a single one number that's never repeated to do that transaction, so you can't steal it and reuse it. These kinds of security mechanisms are much more effective in dealing with the problem of identity theft than trying to close off public records to the public to do the business that the public needs to do, like identify people uniquely, to be able to sell and buy land. So closing off the 600,000 records of the public employees or allowing that to be done is very difficult, hard to administer. As a CIO, it would have been a nightmare for me to try to administer that process. So in closing, and I'll turn it over to Kia, the gold standard for public records access is the marginal cost of reproduction. As a legislator and as an advocate for public records access, that should really continue to be our standard. Anytime you deviate from that, you should have a very, very good excuse. And that good excuse should be mediated by what technology is available and what kind of policy compromises could go in to make sure that the people have access to the records that they have already paid for with their taxes and that are available under the law to be public. Kia?
Thank you. No questions? Okay.
Thank you.
So, good morning, Chairman and other members of the committee. I'm Kia Floyd. I am a Philadelphia native and also the state director of government affairs for the RELX Corporation. RELX is the parent company of LexisNexis. Many of you may know LexisNexis for our legal and professional solutions, but we are really one of the largest data and data analytics companies in the world. So the Nexus portion of that title is really, I think, what you need to know for today. Nexus is really born of public record data aggregation and collection to service the legal industry, the financial services industry, the insurance industry, the law enforcement industry, and a myriad of other public sector and government agencies. As of today, we not only are a large corporate and Pennsylvania employer, but we provide data that is used by everyone from PennDOT to the state police to the Department of Health right here in Pennsylvania to ensure that fraud, identity theft, and other government waste, abuse, and the like are rooted out and prevented. So I think Richard's done a great job in providing highlights of why commercial requests are important. But I'd like to give you a little more insight on how practically we go about doing what we do. Just thinking about, as I've mentioned, law enforcement. Our data is used as investigative tools. We are the little man inside of the computer when you're pulled over for a ticket and they need to decide whether or not to arrest you or let you go. A lot of that data is provided by companies like myself, like ours, I apologize. What we do is integral to allowing real estate transactions to go forward, law enforcement arrest and investigations to proceed. Since 2000, just to mention some of the very, very important things we've done in apprehending and investigating missing persons and missing children's cases. We've helped law enforcement to apprehend more than 155 missing children in the last 15 years. When the Boston bombing occurred, it was our data that was assisting the state police, the city police, and the FBI and being able to triangulate the location of the two brothers that committed the act. So I mention those things not to scare you, but to give you a sense of just how important public record data is for many of the things that you engage in as a consumer and may, quite frankly, take for granted because you don't know who's providing the information that you rely upon. Among the many things that Richard has said, I think the most important thing in my mind is really to underscore the point that commercial entities, commercial requests should not be considered a dirty word or bad word. The fact that we make a profit off of what we gather, it benefits both us as a company but also consumers and Pennsylvania taxpayers because a lot of the data that we collect, surprise, may be inaccurate. It may be duplicative. It may have John Doe listed as John R. Doe instead of John T. Doe. And the difference between the two people is significant, not just for real estate transactions and property ownership, but any number of other consumer and business transactions that people may engage in. We have in certain zip codes within the state of Pennsylvania, just thinking of 19118 in Philadelphia, we'd have, let's say, 50 people with the same general name. How do you anticipate being able to prevent and clean up and perform hygienics on that data if there weren't for intermediary companies like LexisNexis? State governments simply not equipped to be able to address many of the inaccuracies in data, so you hire companies like mine to clean it up and give it back to you in many cases. So the idea that a commercial request is in and of itself bad because we make a profit from it, it just could not be further from the truth. So amongst the many things that I've included in my testimony, and I'll try not to repeat them here, I just want to highlight a few things. When it comes to commercial entities, we do feel that that's the one provision of this bill that should be completely deleted. We don't see any real public policy reason to designate commercial entities as such. We know that on a practical level, when we go into small towns and request a file on whatever it may be, if we are deemed commercial from the outset, we are typically going to be set up for disparate treatment. They see us as a gadfly and a nuisance before we ever are demonstrated to be such. We are not the person who's going into the town hall to request every pool permit. We're going in, as Richard alluded to, in a very very sophisticated, technologically proficient manner. In often cases, we're not even showing up at the town hall. It may be clicking a button because we've got an agreement to retrieve bulk data. So we are not the gadfly or the nuisance that is taking an inordinate amount of time from local town clerks. We are going in with specific purposes to get specific things for a specific need. So I want to make sure that there's a distinction here made between that type of commercial request and what we are doing. I'm sorry.
Out of time for your
okay.
your
Just
slot.
one more point. The home address exemption, which again, and I didn't want to repeat everything that Richard said because he did cover it so well, but the home address exemption is really, really key for us. We are staunchly opposed to exempting state and local municipal employee home addresses through an opt-out provision because we know that that's a very large population of people who still need to engage in all the everyday transactions that I've mentioned. They still need to buy and sell property. They still need to be able to open and close accounts. They still need to have credit extended. If you take their information out of the public record, the primary place where many of our customers depend on us to gather it, you're taking those people off of the grid. It will hurt them more than help them. The privacy concerns that you may be seeking to engender through this bill are really going to be compromised if those people are not able to get what they need because their information was not easily obtainable. So I'll leave that. You do have my testimony. Any questions? I appreciate you reaching out. My contact information is here.
Thank you, ma'am. Mr. Chairman. Thank you, sir. Our next testifier is Mr. Rich Priswara, Executive Director for Westchester University Foundation on behalf of the Pashy Foundations. Good morning.
Good morning. Chairman Metcalf, Chairman Cohen, and members of the House State Government Committee. My name is Rich Priswara, and I'm the Executive Director of the Westchester University Foundation, which is a private 501c3 charitable organization. I'd like to thank you for the opportunity to provide testimony today and the legislation that is before the House Government Committee. The Pennsylvania Foundation Association is an association of private, non-profitable, charitable foundations which support the work of the public universities comprising the Pashy state system. The university foundations were created to provide a private vehicle to solicit and manage private donations for the direct benefit of the students, faculty, and staff at the universities. Like all nonprofit corporations, the foundations have a specific purpose outlined in our bylaws and our articles of incorporation. In our case, it's to advance the educational purposes of the university located in our area. And while the foundations work for the benefit of the universities, they are not part of the university system. They're separate legal entities which provide a private function. University foundations do not receive taxpayer assistance. Each university foundation is managed by an independent board of directors comprised of volunteers, alumni, and friends of that university. They have audit committees, investment committees, and the day-to-day management of the foundation is conducted by an executive director like myself. I hire the staff, create personnel policies, put together benefit plans for all of our employees of this private business. The legal relationship between the University Foundation and the Pashy University is defined as that of an independent contractor, much like many of the other services that they engage in. In our world, we have what's called a Memorandum of Understanding. These memorandums of understanding and other agreements are entered into between the university and the foundation to provide a service and are public documents and can be obtained by any party interested in the legal contract outlining the types of services that we're providing. The Memorandum of Understanding does not dictate how the foundation operates. To the contrary, the foundations manage and control their own day-to-day operations. They typically pay negotiated fees for their fundraising. The university pays a fee to have these services provided, like they do in all other contracts. And the Memorandum of Understanding requires that the foundation provide the university with an annual audited financial statement and review by independent outside auditors. The foundations are private businesses, and they maintain their own business records which reflect the daily operations of these foundations. These records include board of directors minutes, executive committee minutes, tax records, internal policies, procedures. Because the foundations are private, they offer something very unique to donors, which is that these monies that we raise can be invested differently than by the state of Pennsylvania and entities related to the Commonwealth. We have our own investment committees, hire our own investment managers, and try to maximize the dollars that donors give us. Donors feel much more comfortable making a donation to the foundations governed by these individuals with extensive legal, business, and financial management skills. The purpose of Right to Know has and always will be to promote transparency in the use of taxpayer dollars and promoting access to official government information by creating an openness and transparency of those operations. This is an important goal, and we must ensure that public officials and entities continue to be held responsible and accountable when spending the hard-earned dollars of taxpayers. However, the Right to Know law was not intended to apply to private businesses, and certainly not intended to be used as a tool to obtain internal information on private businesses that happen to have a contract to provide a good or services with an agency that is subject to Right to Know. The current language of Right to Know, and more specifically the interpretation by Pennsylvania courts, has adversely and disproportionately affected university foundations. Rather than promoting the transparency in government, the current language and interpretation of Right to Know as applied to the foundations has negatively impacted the public's ability to secure low-cost higher education. This is an unintended and damaging consequence of the current law. The purpose of the testimony is to provide information on these unintended consequences. We have two primary concerns. One is the disclosure of the current law. Pennsylvania courts have interpreted this as allowing access to unlimited number of foundation documents. The Pennsylvania courts have ruled that the foundation performs a government function and all documents related to that function are public. Based on this interpretation, the courts have ruled that every internal document, such as board of directors minutes, donor files, are open to disclosure. This distinction between management of public funds versus the use and management of private funds has been lost in the light of the current interpretation of Right to Know law. By way of example, East Stroudsburg University Foundation, which is a member of our organization, was involved in a landmark case and ultimately ordered by the Commonwealth Court to disclose thousands of pages of donor files, in addition to the minutes of his board of directors meetings and documents. I can share with you candidly that I have dozens and dozens of last will and testaments in my office from donors and alumni to Westchester University. If the chance that their last will and testament would be open to public view, every single donor would demand that that document be returned to them and shredded, and they would cancel their gift to the university. It's a very interesting and complex task that we have to raise money and secure funds. Planned giving, while not a sexy or very public topic, is the primary bread and butter of university, hospital, and charitable fundraising. Millions of dollars are left to our organizations by individuals as they plan the final disposition of those assets, and they provide documents to us so that we can verify, count, and make sure that those assets ultimately end up at our foundations for the use of the students. Imagine yourself, Chairman and Chairman, if you realize that your last will and testament would be available tomorrow to everyone in the state of Pennsylvania. Would you write one? I highly doubt it. And you certainly would not include Westchester University Foundation as a beneficiary of your new scholarship or to create your new speaker series or to fund whatever activity on the campus you value and love yourself. That source of funds, which is our primary and most significant source of dollars, would vaporize. Finally, most recently in the case of Westchester University versus Scheckler, the court alarmingly concluded that the foundations were in large part alter egos of the member universities to carry out activities that the universities want to undertake. In other words, highlighted by both Westchester and East Stroudsburg, university foundations, the current interpretation of Right to Know is that by effectively having a contract with the university, the entire business is open to the general public. If you carry that stipulation forward, then if the university banks at Meridian Bank, all records, all deposit records of Meridian Bank are now open. All the meeting minutes of Meridian Bank's board of directors are open. All the investments, real estate purchases, planning, internal documents are open. We believe that all the documents between the university and the University Foundation are fair game and should be out in the public eye so that the decisions made by the university are available to everyone in the state of Pennsylvania. However, the documents that we have and the strategies that we employ working with donors and the donor decisions to give us funds should not be included in that interpretation of Right to Know. If the legislature intended to include the private university foundations in the law, they could have added university foundations or entities associated with posh universities to the list. The reason the foundations were not included in this list is because the work of the Pennsylvania Foundation Association at that time took time to explain the private nature of the university foundations. But the courts, not the legislature, the courts have chosen to interpret the legislature's intent differently. Pennsylvania Foundation Association does not believe that the purpose of Section 506 was to open wide the doors of every private contractor that happens to have a contract with government. Would we require Staples to provide a list of all of its internal pricing and documents? Time? No. To the public? Why should university foundations be treated any differently just because we have a corporate mission that focuses on supporting an agency who's specifically covered under Right to Know? Overriding purpose of Right to Know has always been to promote transparency in the use of taxpayer dollars, promote access to official government information in order to prohibit secrets, scrutinize action of public officials, and make public officials accountable for their action. In the case of POSH and private foundations, this is occurring because all the legal agreements between the two, as well as agreements for services, are public documents. It is submitted that as drafted, 506D1 casts a net over private entities on the use of public funds without making every foundation a government entity under Right to Know. We've attached proposed language in our testimony for consideration by the committee to resolve this matter. Under the current enacted version of 708B13, a covered agency may withhold or redact records that would reveal identity of donor who lawfully makes a donation to a covered agency, an exemption which the members of the Pennsylvania Foundation support. However, the current law does not provide the same protection to donations that are made on behalf of a covered agency, such as the donations made to the university foundations. We would propose that records,
Pretty much up with your time slot.
Okay. I would just close by saying that our testimony is complete, and I think you can see what we're going for in confirming.
Thank you, sir.
Thank you.
Have a good day. Thank you. Our next testifier is Carmina Taylor, president of the Lincoln University Parents Association.
Thank you so much for being here. I normally don't speak from something scripted, but the words in my testimony are so relevant and so important. And I saw throughout the process some of your colleagues leaving, and I hope that you will share my testimony with your colleagues because it's very important. So I kept it short and sweet.
And there are other meetings that are competing. Normally, that's why you see people coming and going.
I understand.
My understanding was that PCN was also broadcasting, so hopefully your testimony is being heard across the state.
Well, hallelujah. Thank you, Jesus.
For being here.
So anyway, I kept it short and sweet because I know you're bombarded with so much information, but my testimony is so relevant. So I will begin. Thank you, Chairman Metcalf, for giving me the opportunity to testify today on behalf of the tuition-paying parents of the Lincoln University Parents Association. Lincoln University is the only Pennsylvania state-related institution that has been designated as the first degree-granting historical black university in our country's history. Its rich legacy can be captioned by a quote that the founder of the institution, Mr. John M. Dickey, once stated that his institution seeks to realize the great maxim to accomplish the most possible good in the least time. In an excerpt of the 1915 Lincoln Herald publication, the president of the university, Dr. Rendell, reported to the Pennsylvania General Assembly that the importance of Lincoln University rested by the fact that 1,500 students had gone forth from the halls of Lincoln University to lead their race in avocations in honorable and uplifting pursuit, while in addition of nearly 600 or more entered the gospel ministry. He stated that they discovered the work of the university to be very thorough in scope and quality. Such a great foundation for all of us to reflect upon with the seeds that have been laid out for our students today. Now, I apologize because I made reference to the House bill version, but it's still the gist of what I'm trying to say represents that. This bill provides an opportunity for Lincoln University to continue a pursuit to be thorough in scope and quality. First, let me highlight that in Section 1503, it indicates that the respective state-related institution must have a minimum of 2,500 employees in order to be accountable under the provisions of this bill. Lincoln University has less than 1,000 employees. Therefore, we are hoping that the numerical composition of their workforce be included in this bill. Secondly, this bill offers Lincoln University two great opportunities to yield a positive impact for its stakeholders and a positive impact on their sustainability in higher education. In terms of the positive impact on stakeholders, it will achieve the goal that the current interim president, Dr. Green, charged himself at the September 2015 board meeting to improve university transparency, communication, and the spirit of working together as a university family culture. As of this writing, the 2014 and the 2015 Right to Know requirements of reportable information regarding university officer salaries, the top 25 university employees, and the fiscal year 990 forms are not accessible on the website. The 2015 fact book was posted 3 months late on the website. As parents are internal financial investors of Lincoln University, these basic resources of information quantify the university leadership that it quantifies that university leadership is allocating the best resources on the best return on our investment. In terms of a positive impact on sustainability, this bill offers an opportunity for the university to deliver comprehensive information and would ensure an external financial investor the confidence needed to fulfill and support institutional advancement goals and objectives. We believe and agree with this committee that if the state-related institution receives taxpayer dollars, they are also accountable to taxpayers. This bill provides that measurement. Research has also shown that improving accountability measurements in higher education improves their functioning systems, all of which would improve relationships with stakeholders and enhance margins of sustainability that has not been proven to be effective for Lincoln University in the past. This year, members of the Parents Association have made requests to speak at public comments portion of our board meeting, have asked questions, and sought answers via email and phone messages. However, all these basic outreach efforts have been denied, ignored, and unanswered. Our hope was just to understand the correlation and rationale of raising tuition, room, board, and fees consequently consecutively for the last 5 years, but not seeing any improvements on the ground. Even as I sit here today, because the Parents Association has been able to see what is essential for a thriving 21st century Institute of Higher Education, we and our students continue to experience intimidation and retaliation at the hand of university leadership because we dared to seek for them to comply with the existing provisions under the Sunshine Act and the Right to Know law. Without a doubt, my testimony will be interpreted by university officials as an attempt to some way damage the reputation of Lincoln. Nothing could be further from the truth, because our students are enrolled there. We just want them to fix the gaps of services with more effective governance, think more strategically, and unite all stakeholders. As parents of Lincoln, we are committed to do our part, and hope you will do your part in passing this bill. I am a single mother with a senior graduating in May. I have been a member of the Lincoln University Parents Association for the last 4 years and president for the last 2 years. I've experienced a multitude of varying levels of service delivery to us that could be improved upon. My hope is that my testimony in this hearing will be part of a legacy that I can leave for our future families of Lincoln University. My hope as a leader is to pass on better quality of student experiences through university transparency that can be combined with sound business practices that equip the university to be accountable to its stakeholders, sustainable for future donors, and amending this bill provides for that hope. Lastly, I am a taxpayer of the Commonwealth, but more importantly, I'm an alumnus of this great institution. I love this institution for what it has enabled me to accomplish and how it's opened doors of enlightenment for my son and his peers in a way that only a historical black college and a university can provide. Lincoln was founded with the spirit of greatness for everyone who entered their hallowed grounds. Equipping this university with the tools to make it greater will fulfill the roots that were planted. Thank you again for this opportunity.
Thank you, ma'am, for your testimony. Our next testifier is Mr. Eric Arneson, the Executive Director from the Office of Open Records. Good morning.
Good morning. Thank you, Chairman Metcalf. That's a tough act to follow. I'll do my best. Members of the State Government Committee, good morning. Thank you very much for allowing me to testify here today. Senate Bill 411 would make numerous improvements to the right to know law. I've provided some written testimony that goes into greater detail. In the interest of time, I will now just provide a quick overview of the most significant provisions. I may also, depending on how much time I have, make a few comments on some of the issues that have been raised by previous speakers. This bill, most parochially for me, this bill will streamline and improve the appeal process at the Office of Open Records. It's a boring topic to discuss, but it is essential to give us the tools necessary to better manage our caseload. For example, when we hold a hearing or we conduct an in-camera review of records, a private review of records to determine what should be released, that requires significant work on the part of our appeals officers. Open government is good government, and the changes in here that affect the process at the Office of Open Records will make the law work better for citizens. The bill makes reams of financial and statistical data instantly available from the 4 state-related universities, Temple, Pitt, Penn State, and Lincoln. The public will be able to freely search, sort, and download information from online databases at each of those institutions' websites. Importantly, the bill will also apply the right to know law to campus police departments at both state-related and state-owned universities in the same manner that it currently applies to municipal police departments. The bill currently has 2 provisions which affect the release of agency employee home addresses. Some will argue that neither provision is necessary, and it is very clear that both provisions are not necessary. One has already been described by numerous testifiers here today. I'll focus very briefly on the other, which would require that each Commonwealth and local agency develop a policy allowing employees to request that the agency withhold their home address if they believe the personal security exception or some other exception in the right to know law applies. The agency would be required to review all such submissions and inform the employee of its decision. This would only affect requests made to an agency where the employee works. I agree with those who expressed concerns about trying to somehow remove public employee addresses from public records in other settings. It is not something I can envision a way to make that work, even if that was decided to be the approach in the law. I believe the approach I've described would adequately address concerns that have been expressed in various court rulings since the right to know law was enacted, and does strike a good balance if a decision is made that anything needs to be done on the issue of home addresses. I would also note that next month in the Supreme Court, there will be argument in the case of PSEA versus the Office of Open Records, which deals with this issue. We, of course, have no timeline on when the Supreme Court could decide that case, but it is something that is currently pending. An argument will be held next month. Overall, Senate Bill 411 represents a strong step forward for the right to know law. It can be improved, and there is no doubt that other amendments will be considered when the bill advances. I anticipate having a few more relatively modest requests on behalf of the Office of Open Records. And as the House State Government Committee considers the bill and any proposed amendments, I'd be very happy to play whatever role you think it would be most helpful for me to play. Mr. Chairman, I'd also like to point out that, and this does not directly relate to the bill itself, but I am pleased to report that following the House Appropriations Committee budget hearing, I established an internal working group at the Office of Open Records for our draft regulations. That process is moving forward. I'm personally involved in it, and I will continue to push that forward. Thank you again for inviting me to testify. I will take just a couple of minutes to very briefly touch on a few points raised earlier in the meeting. On the issue of, if that is acceptable.
Certainly.
Thank you very much. Quickly, on the issue of whether we should limit the applicability of the law to Pennsylvania residents or not. The testimony about the logic of allowing all United States residents to use the law initially based on court rulings is absolutely correct. Since that time, I have seen many examples where out-of-state newspapers, for example, will become interested in something that's happening in Pennsylvania. So a reporter from the Washington Post or the New York Times, something like that, may want records here. I think that it would be something for the committee to consider the impact of limiting it simply to Pennsylvania residents. We also have numerous examples of out-of-state residents who are active in trying to make very positive reforms to institutions within Pennsylvania who've used the law to acquire records. So just a bit of caution for the committee as you think about that particular issue. On police cameras, I think that the concept of keeping the right to know law as agnostic as possible regarding the format of records is important. It doesn't matter if it's a video record or a paper record or an audio record or some future kind of record that doesn't exist today. What matters is the content of that record, and balancing the exceptions and the public access should apply the same no matter the particular format that a record is in. That is the current status of the law. I understand that the videos do present some novel issues for the committee to consider, but that agnostic nature of the bill in terms of format, of the law in terms of format, I think has worked very well. Finally, I would just point out that Section 506, which was raised regarding private contractor records, has never been held by any court to extend to things like a bank where a government happens to do business, or even a situation where a company has a very specific contract with an agency to do business, to reach further into that company to where we could get, I think the example was Staples' internal pricing documents. Nothing like that has been held by courts. The nature of the state system foundations, the state system of higher education foundations, is different in kind according to the court decisions. And so to the extent that the committee feels that that should be addressed, I would urge a great deal of caution, because I don't think that the situation is anything near as broad as at least I was left with the impression from a previous testifier. Thank you very much, Mr. Chairman. It is an honor to be here before this committee today.
Thank you, Eric, and thanks for the good news on the regulations process moving forward. Any members have a question for Mr. Arneson? I'm sure we'll be in touch in the future, and those modest asks that you were mentioning, if you can get them over to us. And I plan on having a future informational meeting with the committee to follow up on the testimony we've received today, with hopefully a list of changes that have been recommended, and would like to include yours also.
Fantastic. Thank you very much.
Have a good day.
Thank you.
Our next testifier is Mr. Simon Campbell, as a citizen requester. Good morning.
Good morning. Mr. Chairman, good morning, members of the committee. Thank you for inviting me. My name is Simon Campbell. Sitting next to me is Terry Muchler, who probably needs no introduction to members of this committee. She is an attorney at law with the law firm of Pepper Hamilton. And I asked Terry to come with me this morning to provide some insights into some of the questions and other areas of the law that you might have. But I wanted to just address something philosophically, first of all, to start with. When the legislature wrote this law, you wrote it not for any particular group of government officials or foundations or any particular association. You wrote it for everyday citizens, Mr. or Mrs. Smith. And we all have our various different interests, different reasons why we make requests. I have mine. What we don't have is a lobbying group. So I think it is very important that this committee listen to citizens and their experience with it. My personal experience is quite extensive. Terry will remember I might have been one of the first requesters of of requests under the right to know law. I've made many requests of many different type of agencies for many different types of records. I've been to court all the way up to the Supreme Court. So if any of you have any questions after this committee hearing and you want to just call me, you can. You can write to me at my home address if you like. It's a public record under the right to know law, as we know. Come on. See, I knew I could get you smiling. This is my diplomacy part. Let me just say this. Senate Bill 411. Are there some good pieces in it? Yes. Yes, there are. And I think what we should do, therefore, is kill it. Now you're going to say, Simon, why kill it? Because it's like I said in my written testimony. When you buy a property and it's a fixer-upper, you have to make a decision. Do you try to fix it, amend it, or do you just say, let's take the good pieces out, abolish it, and write a new one? And I'm hoping, I can tease one of you into being a chief sponsor of a new bill that takes all of the good things in this bill, all of the good things you've heard about, all of the problems, and write a new one from scratch, and we all talk about that. In fact, what I think would be a good idea is if we had some of these various different interest groups, perhaps myself included, and I'll behave myself, get together in a room, and maybe Terry will be gracious to give her time. I can think of a few other people, other attorneys I've worked with, maybe PNA, maybe OOR, and we thrash out a new bill and then present it to whoever the chief sponsor is. And we basically build a new bill from scratch with the experience that this committee has developed, because I think the Senate, quite frankly, was sloppy in what they did. And there's some things that I want you to understand, and this may be painful to hear. But when you talk about, and Representative Truitt, you and I got into this last time, the concept of regulating requester identity. I don't think there's anything wrong with commercial people. Whatever. You want to make a buck? Who cares? But there's a practical component to it. If you think you can control how records are requested or used by focusing on the requester identity, I'll tell you right now what's going to happen. We're going to have a new era of proxy requesters. You don't understand what that is, right? Well, if you're regulating me, I just pass it off to someone else. I mean, if I set up a website, requestbysimon.com, right? Hey, inmates, put all of your requests into my website and I'll do the request. I could charge the inmates $50 for a request, $50 for an appeal. Judging by how many they file, I'm going to make some good money. And I think the thing is, and it's the same with the commercial requesters, how are you going to stop a commercial requester passing it off onto someone else? If you think that there are issues with the burdensome aspect of the law, I always take the view, first of all, those township officials who have what you might call, what they feel are burdensome people, should just call the requester. There's a lot of common sense that's lacking with some of these folks. If you call me, I mean, I have a certain reputation, but you say, look, Simon, the way you requested that thing, can you just request it this way, not that way? And the way we store it, we'll get it. And I'll be like, sure, whatever. But what do? They come to you guys. Well, this guy's burdensome, help us. And you can't, because you can't really regulate people who live in a free society. So I would just eliminate all provisions of any law that focus on requester identity. Who you are, why you want the records, who cares, really? Judicial branch, they're not following the law. I put a video up on this. I can't believe you file a right to know request of any court in this state, and they'll tell you we're not following the law. They literally don't follow the law. They've decided they have a rule which provides less access to records, which is in blatant disregard of Section 304 of the Right to Know law, and tell the citizen, we're going to impose this rule on you. I think the legislative branch should sue the judicial branch. AOPC are behind this. And I think you've got to look at this and make some requests and give me a call and see what some of your common police courts are saying. Like I said, I think this bill, if you kill it and get the people together in a room, and we'll all try and get along with each other, right? Present a new bill. That's the way that this committee should move forward, rather than trying to amend so many different things, because there's so many things that are not workable from a court legal perspective in this. If you don't define something specifically, what happens is an agency can deny the requester and then go to court to get a court to say, there's no legal definition for this phrase. I see a lot of exemptions that were put in this bill. Eric was saying the bill's good. I don't think the bill's good because it exempts pretty much anything around employee choice of taxpayer-funded benefits. I don't think, when you're choosing to contribute to a public pension system or a public health care plan, that should not be an exempt record under the Right to Know law, because it's a publicly funded system. Yet so much more information is exempt under the personal financial exception. I wanted to ask Terry to talk about the non-criminal and criminal investigation exception, because I've personally experienced what Melissa Malewski was talking about, where it's just overbroad, where they can just kind of deny and say, well, we're doing an investigation and we're denying you. And I think some restraints need to be put in that, and I just wanted Terry to talk about that. But also the third-party foundations, these private organizations that say, you know, we need to be protected. I wanted just to ask her to address some of the things that she's seen in that regard. And if we do have time for Q&A, I would love to take them.
Mr. Chairman, good morning, and members of the committee. Thank you for the opportunity to appear here. I'm appearing in a limited capacity in relation to Mr. Campbell in a case we're handling for him. The 2 points that he would like me to speak with you about, I do think are important. I would be remiss if I didn't say that while it was a great privilege to be the first director of the Office of Open Records, I think that by all accounts, I think that Mr. Arneson will end up being the best director of the Office of Open Records with the changes that we've seen so far that he's implemented and the refinements and improvements. And I echo many things that Mr. Arneson said this morning. With relation to criminal non-investigative components, I'd just like to point out to the committee that while Pennsylvania went from 49th in the nation, 49th worst, to as high as 5 in some rankings under the right to know law, I think that the drag on the right to know law that is going to keep Pennsylvania from not attaining those top spots is because of the criminal investigative component. In most states, when an investigation is closed, you are able to obtain some information. Here in the Commonwealth of Pennsylvania, you are unable forever to obtain any information even after an investigation is closed. Prime example, New York Times came to the Office of Open Records seeking records through the state police of a fire that was over 150 years old, and because these records are not available in perpetuity, they were not able to be obtained. We ended up mediating that, and the news organization got those records. So I think that there's a way to certainly honor and recognize that you can't be releasing criminal investigative records during a process. But when the investigation is closed, I think that it would be incumbent on the legislature to take a look at ways to open portions of that. The second component, the other two components, in relation to the previous testimony, I echo the executive director's remarks related to PASHI and those committees. There's two things I think it's important for the committee to know. First of all, donor names are already exempt under the right to know law, and the decision that was mentioned, East Stroudsburg versus Barrett, specifically said that donor names are not available, that it's the financial information. I think it's important for the committee to understand where that case came from. A reporter at the Pocono Record filed a right-to-know request seeking information from East Stroudsburg University related to allegations that a university official was trading sex for scholarships, and they attempted to garner documents related to this and other information. That came to the Office of Open Records at the time. The office ordered that it was, that the records were public under the law as a governmental function that was being performed. So I think it's important for the committee, if you're going to be looking at the East Stroudsburg case, to actually look at the case and look at what the court said in a 7-0 decision at the Commonwealth Court, that the relationship between the foundation and the universities are contractual, and it's based on the fact that the foundation is performing a statutorily given governmental function of fundraising. So for the concerns related to donor names, I just would ask the committee to be cognizant of that. And the last piece is related to, studies under the right to know law and investigative material in that way. I think that I would encourage the committee to take kind of a national perspective of this when you consider this particular section, where if you look at Flint and the water studies, you look at Newark and the water studies, there's a lot going on around the country right now in relation to water quality, whether it's Marcellus Shale or otherwise. And I think that this rewrite to the right to know law, which encompasses some very good components, and I think does great things for the Office of Open Records in terms of appellate procedure, I think also you need to kind of keep in account, as Mr. Campbell mentioned, the purpose behind the law, and keep in mind that there's a lot of information in everyday life, those water studies, different things like that, that could be incumbent. And with that, Mr. Chairman, it's I have to say it's not only an honor to be before the committee, but it's a great relief to not be in Mr. Arneson's role. So thank you.
Can I just wrap up our testimony here, Mr. Chairman, by saying, to me, the biggest issue with the right to know law, and I'm going to do it in my usual colorful way, is the fact that I can afford an attorney like Terry Muchler. I want you to think about how profound that statement is.
I'm not that expensive, Mr. Chairman.
She's not, and she's very nice. But I want you to think about one of your constituents. What if they couldn't afford an attorney? Have you ever thought about that? We hear a lot about, do we want a law that says if you can afford an attorney, you can get records, and if you can't, you can't? I don't think so. When you think about all these folks that are complaining about burdensome requesters, what about the request of your constituent, Representative Truitt, since you're looking at me? I always think, what's going on? What happens if they come to you and say, I want an OOR, they took me to court, I won again, and I'm down $5,000?
Let me just interject there. I've turned away at least 10 citizen requesters who've come to seek legal counsel for, obtaining records after they've obtained a favorable decision from the Office of Open Records. Many of those cannot, handle. They just don't have the money that Mr. Campbell apparently has access to.
Well, no, limited.
To do that. So I want to underscore that does tend to be an issue.
It's a problem in that no matter how great of a bill you guys can write, think about this for a second. All the agency has to do is say, we're denying, we have an argument. They might be wrong in that argument, but that they have taxpayer-funded lawyers to make the argument. And that is a huge issue because we're talking thousands of dollars at the court level. And I think there are some original ideas that the Senate never even looked at that you could put in place in a new bill, which is why I would encourage you to write a new one, to protect the citizens who prevail at OOR. Think about it. Who prevail, who win, yet who are then at risk of being taken to court. There are some ideas that you can put into the law, and I would encourage you to look at my written testimony, and maybe we can continue this on another date.
Thank you. Questions? Representative Truitt.
Okay. You make a good point. I've often been an advocate for laws that would say in a case where you have litigation that the loser should pay for legal expenses. So are you saying that if a citizen requester is denied and then they take it to court and they win, they should be reimbursed for their legal expenses?
Exactly. And if you really want to get creative on this, Representative, I would even suggest that maybe, and Terry and I were talking about this before we came in, supposing you win OOR and they take you to court, how about the idea, and yes, this would be government funds, of having the equivalent type of a public defender almost attorney that defends the OOR's decision on behalf of the citizen. So the citizen doesn't have to pay a lawyer out of pocket and then hope that they get their money back. Maybe, we have a government-funded OOR. So if the OOR says, open records, you win, citizen, and the agency goes to court, maybe that citizen gets the equivalent of a public defender attorney, or at a minimum, if they lose at court again, like we said, maybe you could write it such that you automatically pay the citizen's legal fees. In other words, put a disincentive in place.
That's already in the law, Representative. There is a component that either side, if there is a frivolous claim, attorney's fees can be recouped. And also, there's also a penalty provision that courts are starting to use, where if an agency is in bad faith withholding public records, they can be fined up to $1,500 and also up to $500 per day for any day that the court orders and they don't release. And I would encourage the committee, this was not my idea, but it's a good one, to add language that says that if they don't comply with an order of the court or the Office of Open Records, that would be in play.
Yeah, but what I'm talking about is a little bit more than that, because I have argued that provision of the law in Commonwealth Court. I said it was frivolous that the Governor's Office of Administration denied me counties of residence. They said that that should be denied as a personal security exception. Counties of residence. I told my lawyer, argue bad faith penalties. This is clear cut. That's frivolous. The court wouldn't give us legal fees. We won. The court said, of course, it's not personal security. What I'm saying, Representative Truitt, is if the court upholds the OR decision, that you guys make it automatic, pay the legal fees. Done.
That's what I thought you were saying. But your analogy of your proposal of having like a public defender. Now that means if they lose, then the state's still paying. My suggestion would be is if you win, the state pays, and if you lose, you pay. Is that a reasonable?
I think that's a reasonable balance. Yeah, if you lose at OR, then you get no government-funded help. But you can still privately hire an attorney. But if you win, and then the agency appeals, tries to get it overturned, that you automatically have government protection.
Just one addendum to that. I think there would have to be a provision because there are many citizens in good faith that apply, file a right to know request, and in good faith agencies deny them because it's not a component of the law. You have to remember that the right to know law is still relatively new, and we're kind of still kicking the tires on a lot of components. And so if a new angle got tested and it was a good legal case and a citizen lost, I don't necessarily think that they should pay legal fees just because they have lost. I think there has to be, you have to capture in the language that Senator Pileggi already captured in there, which was frivolous. And if it's frivolous, I do agree with your proposition in that regard. But I think you have to leave a little bit more breathing room.
Then determining frivolous is a bit subjective. Then, right?
Well, that would be up to the court.
County of residence frivolous? I thought so.
Oh, yeah, you're right. Okay, thank you. Very good.
Thank you for your testimony today.
You're welcome. Thank you.
That concludes our testimony for today's hearing. I think it's obvious from the testimony we've received today there's a balance that needs to be found with the suggestions that have been made, and look forward to working with the committee and testifiers as we move toward that in the future. So, motion to adjourn by Representative Truitt, seconded by Representative Tauber. This meeting is adjourned. Everyone have a great day.